Thank you very much for joining this seminar. I'm Lucy, as Marika mentioned. I'm the criminal lawyer. I'm attorney at law in Czech Republic. And my law office is highly specialized in domestic and sexual violence, not only victims, but we also do the defense law. And I'm working with victims of domestic and sexual violence in Czech Republic for more than 20 years now. I was also a volunteer for White Circle of Safety, which is an NGO helping protecting victims of sexual domestic offenses in Czech Republic. And I was there as a volunteer for 14 years. Since I'm working with the victims of the most vulnerable victims of all the crimes, I think I can share some experiences, and I would like you, if you have some experiences too, to share them with other participants, so we can, start some discussion if you like. So if you have to add something to my comments, feel free, please. Today, so can you please move with presentation for the next? Thank you. We're going to talk about current European Union legal framework to protect women against violence. The European Union is trying to help to protect women from the violence through the range of measures. And we have two important areas where the EU is taking action. The first one is ensuring recognition in member states of other member states' victim protection decisions, both criminal and civil law. This is very important because only in the combination of criminal and civil law we can fully establish the protection of the victims. And this is very important. So please remember that for your work. If you're going to need some legal actions, please remember that you have to fulfill the right of the victims in both areas. So the first one, in the criminal proceedings, the recognition of the decisions in criminal proceedings is governed by the Directive of the European Protection Order. So we're going to talk about it furthermore. And the other one, the recognition of this the decision in civil proceedings concerning the protection of victims is governed by the regulation on mutual recognition of protection measures in civil matters. I just want to remind you, I think everybody knows that, but please let me remind you, a regulation is a binding legislative act. It must be applied in its entirety across the European Union. A directive is a legislative act that sets out a goal that European Union countries must achieve. However, it's up to the individual countries to devise their own laws how to reach these goals. So there are the differences between regulations and directive. But together, these instruments will ensure that victims of violence can have their protection orders recognized in any European Union member state. The mechanism takes into account the differences between protection measures in different member states, which may be civil, criminal, or administrative, because please do not forget that in some countries, what in your country can be administrative delict, in other country can be criminal delict, and vice versa. So all of the areas of protection have to come together. Together, these rules will ensure the free circulation of the most common types of the protection measures within the whole European Union. And we have the third one, the Victims Directive. And this directive establishes minimum rules of standards for the protection of victims of crime to be injured by a member state. So now we're going to talk about Directive on the European Protection Order. So as is written on the presentation, as you can see, the directive is a directive of European Parliament and of the Council of 13 December of 2011. And it entered into force on 10 January 2012. The purpose of this directive is to ensure continuation of protection against criminal activity granted to a person to the underlying decision. This is the protection measure issued criminal proceeding in one European member state in the territory of another state of the European Union. The basic concepts is that the European protection orders in Article 2, paragraph 1 says that a decision taken by a judicial or equivalent authority of the member state in relation to a protection measure on the basis on which a judicial equivalent authority or another member state takes an appropriate measure or measures under its own national law with a view to continuing the protection of the protected person. The protection measure, they are in Article 2, paragraph 1 of the protection order, explains the decision in criminal proceedings, that individual member states regulate who makes such a decision differently. This is what I was talking about, that in every country it is different. It could be judicial, it can be police or administrative authority. For example, in Czech Republic, it is a court, and it could be the single judge or the Senate, but it can also be the prosecutor in criminal proceedings before the court procedures. So it really depends on the type of the proceedings in every country. Selective, do you have some contributions? How it is in your country, for example? Please do not hesitate to tell us. But in Czech Republic, it is a court, which can be a senate, a single judge, or the prosecutor. Depends on the case and the type of procedures. Selective types of offenses. This is very important because this protection order can be issued if it was a criminal offense which may endanger life, physical or psychological integrity, dignity, personal liberty, or sexual integrity. So you can all see that this is something which is very common in domestic or sexual violence. It's a partnership abuse, most likely. It's an intimate, we also call it intimate violence. And this all can cause very hard, it can also be very, I don't know how to say that. It should be very vulnerable for the victims. That means that all of the actions of the perpetrator will probably cause some damages on the victim's mental health, physical health. She will have some issues, or he will have some issues, definitely. Please do not forget that victims of the sexual or domestic violence or intimate violence, it depends how you call it in your country, can be men, can be women. All of them can be in all types of relationships. Also, it can be a minor, it can be an old person, it can be somebody with mental or psychological or physical indispositions. So we have all types of victims here, but the principle is that we're trying to protect them by the type of the selected type of the offenses. Do you have any questions? If you have any questions, please do not hesitate to ask me. As you can see, I'm a victimologist. The victimology is a science about the victim, about the impact of the crime to the person, to the life, which we're trying to find out consequences in the life of the victims. We're trying to find the mechanisms, the proceedings in the victim's life, health, and stuff like this. So I'm a victimologist. I'm teaching victimologists, teaching victimology in Czech Republic to doctors, judges, and stuff like this. So I will add to my presentation more of the victimology because I think that is very important. And it's a combination of criminology and psychology. And it's something then these two sciences meet together. And I think victimology is very important nowadays for courts, for police, but also, for example, for doctors or for teachers. So I think the basics of the victimology should be well known for everybody. So if you don't mind, I will just add some of it to my presentation. So it's not going to be only about the Black Letter Law, but it will be also more about victimology because I think I consider it very interesting. So I hope it's going to be interesting for you. So in relation to use of the European Protection Order, this includes the offenses of stalking and domestic violence in particular. This is what I was talking about before. The selective type of restrictions is very important. At the same time, the measure must impose on the person one or more of the following restriction, and this is in Article 5 of the directive. So you can find for yourself in Article 5. A is a prohibition from entering certain localities, places, or defined areas where the protected person resides or visits. This is important, not only resides, but also visits. That means it should be also for temporary places, and that means the protection is for the victim whenever she goes. This is or he goes, very important stuff. B, a prohibition or regulation of contact in any form with a protected person included by phone, electronic, or ordinary mail, fax, or any other means. In Czech Republic, if we use this type of order, we also can add there WhatsApp communication, Skype, Telegram, so whatever, also Instagram. So that it is better if you not only write there all electronic communication, but if you also point out for some services, because the perpetrator should be very clear in that where the victim should be not contacted by. C is a prohibition or regulation on approaching the protected person closer than a prescribed distance, and this is about stalking. As you can see, the two first, A and B, was more about intimate violence and partnership violence, but the third one is for stalking. And stalking is highly presented where we call it not the intimate violence, but the separation violence. And separation violence is where the domestic violence, the intimate partnership violence is ended somehow. The victim runs or is protected by the states, even though if she don't want it, for example. And then the separation violence starts. And it means that it somehow continues, but without the part which is intimate. It's something for the long distances, but it still continues with the same measures, with the same ways. And stalking is kind of continuation of the domestic violence by different ways. And this is what we have to have also in mind, that the ways that the perpetrator stalks the victims can or should not look or mean to us as very important or endangered to us. But for the victim, she will probably feel very endangered by the ways of the perpetrator is following her, stalking her, contacting her, because she had an experience with him, or she. The sound is very poor. You don't hear me?
I hear you quite fine. So I'm not sure what the problem is. I understand you perfectly fine.
Yeah. Okay.
Yeah.
Okay. So I will continue. Just tell me if there would be any problem, please.
I won't worry.
Yeah, so the stalking is somehow continuance of the domestic or intimate violence or the partnership violence, and the victim has the most that's very common, has her own or his own experiences with the stalker, with the perpetrator, and that means that seeing it through this history, through this experience, she knows what to expect and she feels threatened. So that means if you look for it, if you are, for example, the judge or the attorney or the police officer or the state prosecutor, the one who is going to ask. Oh, it's not for me. I'm sorry. I'm reading the chat here. So if he's going to ask or issue the measures according to this protection order, you have to think about it from her perspective, not from yours. This is very important. You have to think about from his or her perspective. I'm sorry. In Czech Republic, the victim it's a feminine, so this is why I'm mostly using her, but it should be him definitely, or there. So to ensure yourself that you are thinking the same way as a victim, because she should be threatened more in her place, because she has experiences with a perpetrator, and this is very important, and this is what I, as an attorney, as an active attorney who's fighting for victims or advocating for victims here in Czech Republic and representing victims, I feel there's a lack of it in Czech Republic to see the situation from the victim's perspective, which is definitely different than the perspective of the one who is going to decide, of the authority who's going to decide. So please have this always in your mind. So we have to consider that it is a decision made in the middle of proceedings, or it can be also the final decision of the case, or it could be a follow-up decision in enforcement proceedings. So there are all the types of measures that you can use according to this directive. The protected person is a victim, or the person who is the object of protection, and this is the difference. There are two protected types of protected person according to this protection order. One is a victim, and the other one is called secondary victim. It can be secondary victim. It can be somebody who's living together with the primary victim. So that means that the violence is not target to the other one, but for example, a minor child of the victim can see it, can hear it, is present to the violence. So that means that he or she, the minor, has to be protected too, even though it's not the primary victim, if you understand what I'm saying. The person causing danger is offender, or the person whom the restriction applies to. The practical use of this protection order. This will help victims who decide to change their residence and move to another member state, but still fears that the order that will threaten that the offender will threaten them abroad. That means I was living in Czech Republic. There was my stalker, and he was convicted. And I'm really moving away to Slovak Republic or to Germany, but I'm afraid that he's going to threaten me via emails, he's going to stalk me via all my social networks, or he's going to stalk me in person. So this is when I can ask for the protection order. Typically, in the cases of domestic violence, the victim decides to leave the abuser, moves away, the abuser continues to contact her and threaten her, and she decides to file a criminal complaint. A decision is made that the offender is not allowed to approach the victim. Victim moves abroad. The offender contacts her and tells her that he knows where she lives and that he will find her and kill her. She wants to be protected from the offender abroad and doesn't want to deal with criminal proceedings abroad again, because it's long and it takes the time and the money and also exhausts you physically or psychologically. So you can apply for the European Protection Order in your new country. So please, next picture. Thank you. The European Protection Order issuing process. The authority issues the underlying criminal decision restricting the offender from acting in relation to the victim. This is the first part. The protected person, the victim, applies for a European Protection Order in state that issued the underlying decision. Then the national authority decides to issue a European Protection Order to reject the application. If it issues the European Protection Order, the state authority sends it to the state in which the victim wants to be protected. The state decides whether or not to accept the European Protection Order, and if it recognizes the European Protection Order, it will follow up measures. The part of the directive is the form for it, so the victim can simply fill it up, and it's in Annex 1 to the protection order. Incorporation of the directive in Czech Republic. So because I'm from Czech Republic, so I can talk about Czech Republic. So it's in Czech, zákon o mezinárodní justiční spolupráci. In English, it's an act on international and judicial cooperation in criminal matters, which amended certain provision in Czech Criminal Procedure Code. And for example, restrictive measure in Czech Republic are first, preliminary decisions or interim measures, as you like, and it's before a final decision. So we can prohibit the contact with the victim, the prohibition to enter the common home and its immediate surrounding to remain as such home, which is the part of the Criminal Procedure Code in section 88. The prohibition to stay in specified place. And this is all interim measures, preliminary decision. That means that it can be issued in just very immediately, and it can be issued like in the second day, 24 hours, according to the decision of the state prosecutor or the judge. And it can be also the part of the final decision of the court, and it's only the final decision of the court, not of the state prosecutor. And in a final decision of the court can be also the prohibition contact of the victim, prohibition to enter the home and stuff like it. And it all protects the victim altogether in criminal procedures, and it's very quick, and it's very safe for the victim, because it's not going to include the interrogation, giving a testimony, going to the expert again, because it's very harsh for the victims, to say it honestly, in Czech Republic, and I believe it's the same in other countries, that even though if the police officers and the courts and the state prosecutors, they're doing their best and they're very kind, and they're trying to protect the victim, as much as they can, but still it's very harsh for the victims. And if there is one part missing, or some officers or the judge is misbehaving, or they're not acting, kind, or they're rude, or they're doubting the victim and stuff like that, it's causing, we call it secondary victimization. It's secondary harm. And this term is used by the victimologists, but it's also the part of the third one, we are going to talk about the Victims Directive. And that means that if somebody committed a crime and you're the victim, it's the first victimization that you suffer, the first harm. But then in the proceeding, and it depends whether it can be civil proceedings or administrative proceedings or criminal proceedings. If there are no standards for authorities how to treat you, and they're rude and they're doubting you, they will probably cause you a secondary victimization, a secondary harm, which can be worse than the first one. So all of this stuff, all of the protection, all of these protections or the directives and regulation are trying to protect the victim from the secondary harm. So now we're going to talk about, sorry, I need to drink. The regulation on mutual recognition of protection measures in civil matters. So this is the second one. It's very important, and this is a regulation, not the directive. As a regulation, it's a binding legislative act, and it must be applied in its entirety across the European Union. It's closely related to the previous directive for the criminal law. And together with it, it regulates a recognition of protecting measures serving to protect victims. The directive ensures the recognition of decision in criminal proceedings, but this regulation provides for the recognition of decision containing protection measures in civil matters. So this was what I was talking about, the combination of all stuff together, of all procedures together. These two institutes have some synergy, and they're similar in many ways, but they are different in some ways. For example, they differ in procedures and processes. The main facts about this regulation is that it entered into force in 2013, and purpose is to ensure mutual recognition to protective measures in civil matters to strengthen victims' rights in European Union. The process, according to this regulation, is different from the European Protection Order. A civil decision is issued, which, like the European Protection Order before in a criminal procedure, is issued to protect the victim. This is clear. It must be a protective measure regarding, and there are three parts. Again, prohibition or regulation on entering the place where the protection person resides, works, or regularly visits or stay. Please mind again that I'm pointing the regular visits or stays. That means that she doesn't have to own the house or the flat. It should be, for example, place of her mother when she or he, the victim, is going to visit very often. It can be also the school that she visits visits very often. Second is a prohibition or regulation of contact in any form with a protected person, included by telephone, electronic or ordinary mail, fax, or any other means. So that you can see it's very similar to the European Protecting Order in criminal proceeding. They are the same measures of protection. And C is prohibition or regulation on approaching the protected person closer than a prescribed distance. So this is again for stalking. So the first one is for domestic violence and the third one is for stalking again. The authority of the state is that issued in a civil decision shall issue a certificate and inform the person who is restricted by the decision that it has issued a certificate. So what it is there in this certificate. There is a name and address, a contact details of the issuing authority, so you know who is ordering you to stay somewhere or not to go somewhere. The reference number of the file, to issue the day of the certificate, details concerning the protected person, details concerning the person causing the risk, and information necessary for enforcement of the protection measure, including, where applicable, the type of the measure and the obligation imposed by it on the person causing the risk, and specifying the function of the place and or the circumscribed area. This is what I was talking about when I was talking when she goes and when she or he visits. The risk, and specifying which the person is prohibited from approaching or entering. The duration of the protection measure and other stuff. So it's very precise, and the wording has to be very precise in there, because you are deciding whether somebody should enter a building to go somewhere, and it's very it's very high density of impact of the personal rights. The certificate issue in European country is valid for 12 months. Even if there's a safeguard measure lasts longer, the certificate is only valid for 12 months. The protected person must be then present in the country in which he or she wishes to be protected. So that means in this country need to present a copy of the prosecution measure which satisfies the condition necessary to establish its authenticity, and the certificate issued by the member state. The authorities of the other country shall then issue its enforcement and, where necessary, modify the factual elements. I can give you an example how we use it in Czech Republic. For example, the institute of expulsion is in act according to the police of the Act on the Police of Czech Republic on interim measures, preliminary decision, and the matter of the matter of protection against domestic violence according to special court proceedings. So we have in Czech Republic in civil law we have two types of proceeding. In civil law, I already talked about the criminal law that you can ban somebody from the house or from the victim and to expel them from some such places. But this is the criminal law. But we're now talking about civil law, and we have two types of this decision and the proceeding. One is for the police, and in Czech Republic it works like that the police can expel somebody if they come to the house and they see the fight or the victim, they see the blood or tears, or somebody is calling that somebody yelled there at the kids. So the offender can be expelled for 10 days by the police, only 10 days. And this is not a criminal procedures. This is a civil procedures, or maybe we can call it administrative procedures. And in these 10 days, he cannot contact the victims. He cannot contact her via email or any electronic device or any services, and not even through the other person. That means that, for example, if the perpetrator will go to the mother of the victim and try to pursue her to contact the victim, so for him to be I don't know, so please take me back, I'm not going to do it again, just forgive me, and try to force her from for example, the the divorce or filing the divorce, then it's a criminal offense in Czech Republic. So if you try to contact victim in this 10 days, it's a criminal offense. And then it would go to the criminal procedures. In that 10 days, the victims will get the contact to NGOs or which are helping the victims of domestic violence or partnership violence. And we also have the interventional centers that they are governmental one, not the NGOs. And they're psychologists and a lawyer, and they're trying to help the victim, to tell her how to file a divorce case, how to ask for alimony or the maintenance for the kid, trying to help her to ask for the preliminary decision about the minors and stuff like that. And this police decisions, this 10 days decision can be prolonged by the court, by the civil court, if the victim or the social services in cases of minor ask for it. And also the court decision protects not only the victim, but also protects the people, the secondary victims, the people who should be protected too in the same family. Typically, they're minors or an elderly person that they are living there and can be secondary victims of domestic violence. Secondary victims is an official term of victimology, and that means that you see or testify or hear the violence, which is not aimed to you, but to another person, the primary victim. But for example, let me add some victimology facts. If the minor sees the domestic violence of a mother or a father aimed to a mother or a father, it has the same impacts on his or her psychological state in the future as if he would be a primary victim. This is very important because we somehow tend to diminish or doubt the impacts of just to see the violence or to hear the violence, because it's always like, let's close the door and then beat the victim so the kids won't see it, but they can hear it, they can see what happened there, they can see the bruises, they can see tears, they can hear the scream, they can see demolished furniture, for example. And this all, according to the psychology of the minors, has the same impact for their future life as if they be the one who was beaten. This is very important. So this is why we should think in these measurements, in these steps to protect not only the primary victims, but we have to all think that there are secondary victims there. And in Czech Republic, this the preliminary decision of the court can last for 6 months, but it can be also, but it has to be prolonged every 2nd month. So this is how it works in Czech Republic. If you want to share your experiences in your country, well, we can maybe see, maybe you have you have better procedures and we can somehow learn from you. So do not hesitate to share it, how it works in your countries. But what I'm trying to say, that these two kind of protections combined together should protect the victims. And the problem is that these orders are not so well known to the authorities. For example, I'm talking for the Czech Republic because I'm a teacher and active lawyer here in Czech Republic. So it's not so well used. And according to my experiences, we mostly use our protective measurements in Czech Republic according to the Czech law. Then this regulation or directives or this regulation, because it's simpler for us, and we're used to it. But it exists and it should be used because it's quicker for the victims. So let me talk about the directive, please. And this is my favorite team. Yeah, I'm sorry. I don't think we're going to the decisions of the court justice, because it's already 9:45. But I think the directive is the most important step. And I already sent you the presentation, so you have it there. But let's talk about the directive. Directive is the most important of all, because this directive establishes the minimum rules for the protection of the victims of crimes to be ensured in member states. And we have it since 2015. So the directive lays down the minimum standards for all victims of all crimes, regardless of victim's nationality or resident status. This is very important. So it's for all persons, whether they are from third states, for all around the world. As soon as a crime is committed or a criminal proceeding takes place in European Union, the victim must be granted the rights established by the Victims Directive. And for me, I started working with the victims in criminal procedures in 2002, when there was no there were no standards for how to deal with the victims, and we were thinking of the victim as for the object of the criminal procedures, not the subject of the criminal procedure. This is very important, because this directive it's changing the victim's perspective, and it's changing our perspective, how we measure the victims, and we have to consider the victim as a subject with rights, and this is very important. So the content of the Victims Directive is that it has both specific rules and the list, which is of important terms, rules of information and communication regarding the criminal proceedings. So to understand and to be understood during the contact with an authority, for example, plain and simple language. This is very important, because the victim is harmed. The victim has a problem to understand long sentences, for example, because if you are in shock, or if you are in, for example, PSTD, post-traumatic stress disease, your cognitive functions are very low. And it's not about the IQ, it's about the stress, and it's about the psychological harm. So you need to use a simple language when you're talking for the victims, for example, when you're explaining her rights or his rights. To receive information for the first contact with an authority. So you get a list of everything, which is your right, the NGOs, when you can go, the asylum and stuff like that. Then you can make the formal complaint and receive written acknowledgement about it. Rights for the interpretation and translation. And I can speak of this directive very long, because I'm using it daily, on the daily basis, and I'm also teaching about it for the Council of Europe. So just let me say that all the rights relating to participation in criminal proceedings for the victims are very important, because this is the rights that make the victim the subject of the criminal procedure, not just the object, not just something, to explain where or what happened, and, how it happened, and when he perpetrated the body, or he or she, but, that the victim is somebody who should be protected because of the secondary harm or secondary victimization, but also that the victim, he or she, has rights to ask, to be informed, to be participate in the criminal procedure, in the hearings, that victim defines the special special types of victims that have more rights. For example, in Czech Republic, the victim of the rape can ask to be interrogated by the sex who or she is she wants for. So women, men, it depends on her what is more suitable for her or him. So this directive defines who is a victim with specific protection needs and what special rights are granted to them. In the context of individual assessment, particular attention shall be paid to victims who have suffered considerable harm due to the severity of crimes. Victims who have suffered crime committed with a bias or discriminatory motive, which could in particular be related to its personal characteristic. This is very important because before we were not looking at the victim as somebody who can maybe be harmed because of what? Because he is or she is related, or can be gay, or can be diminished somehow because of the part of the minority. And we weren't thinking about victim in that terms before. We were just, thinking that all the victims are the same. And now we have to think that no, they're not the same. And because of the crime was committed, maybe there are some relationship and dependence of the offender, that makes the victim vulnerable. Maybe it is some bias that I can have that victim is particular vulnerable. That means that we have to think more as the attorneys, as the judges, as the police officers, as the lawyers. We have to think about victims. And this is very important because now we found out that the criminal procedures is not just about the perpetrator, but it's really about the victim. And these two stuff really needs to go together. We have to aim the victim the same as we aiming the perpetrator. The protection of the victims with specific protection needs. The directive talks about right to avoid contact between victims and offenders, right to protection during criminal investigations, that interviews are conducted without undue delay. The questioning of victim is to kept to the minimum. That means it should be, for example, recorded. So the victim cannot be questioned again at the police officers, then at the prosecutor, and then at the hearing at the court. If you record the victim and there are attorneys and maybe there should be judges, for example, in Czech, according to the Czech Criminal Procedures Code, then it's the end for the victim, and she or he doesn't need to go to the court. The right of the child victims during the investigation. This is very important because children are very vulnerable in the criminal procedures. The right to have statement audio recorded. This is what I said. And also introduces training of practitioners. This is very important to me because in Czech Republic, we don't have a mandatory training for judges. And since I'm a trainer of judges and I'm trying to change the law in Czech Republic with a lot of other people, obviously, and we're trying to establish the mandatory training for judges in victimology in Czech Republic. And according to the directive, member states shall ensure the officials likely to come into contact with victims, such as police officers and court staff, receive both general and specialist training to level appropriate to their contacts with victims, increase their awareness. So this is what we are trying to achieve now in Czech Republic, because now it's just voluntary, not the mandatory, these trainings, because I'm training the judges, and there are always the people who wants to hear. It's like you want to hear, you want to learn, you want to know more. And the people who should know more, because they are in the process, they are the one who's the authority going to decide, they are not here. So it's always the same. So I'm really grateful that you're here, and you want to know more about the protection of women or the victims. This is very important for me, and thank you for that. In Czech Republic, it was incorporated by our own law of victim protection in 2013, but it was fully incorporated in with the amendment in 2017 in Czech Republic. For example, now we have very good definition of a particularly vulnerable victim, but we're trying to add more types of criminal offenses. For example, not just a rape or domestic violence, but also sexual offenses, which is not there now for these victims. So we're trying to make it better now, but it has some problems in our country, and we're trying to make it happen because now we have kind of momentum in Czech Republic because we have some big criminal cases with multiple perpetrators. For example, one perpetrator of the doctor who offended more than like 100 victims in 40 years of the praction. So now we have a momentum, and we're trying to change it to move the women or victims protection like furthermore. But we have to try. It's hard.